Always trust.
We ask the questions.
What is needed in the world?
Is that going to
Pravnik iz Velike Britanije, našem je dijelu Europe poznat kao tužilac iz Haškog tribunala, posebno iz procesa protiv Slobodana Miloševića. Poslije toga se uglavnom bavio predmetima na Međunarodnom krivičnom sudu. Angažovan je u nekoliko nevladinih organizacija, često drži predavanja. Geoffrey Nice za Al Jazeeru je govorio tokom posjete Sarajevu sredinom maja na konferenciji Genocid u Srebrenici ka trajnom sjećanju.
Sir Geoffrey Nice, thank you very much for being with us.
My pleasure.
20 years after atrocities in Srebrenica, have those crimes met the adequate punishment in terms of judgment?
Many people would say not. There are individual convictions and acquittals that are either thought to be inadequate because they didn't find, for example, genocide, but only a lesser crime, or in the case of acquittals, because people were acquitted altogether of involvement in the crimes at Srebrenica. But perhaps more significant is that the state of Serbia has so far, not by the ICTY, but by the International Court of Justice, not been found directly culpable for genocide at Srebrenica. And that, I suspect, is in the eyes of many here in Bosnia and many around the world, an unsatisfactory result. Whether anything's going to be done about it is perhaps something we'll turn to in due course.
What does it mean, due course? And do you think that there was and there is enough evidence for Serbia to be convicted at the International Court of Justice?
Let's be completely candid. Many people thought there was sufficient evidence for a conviction of genocide at the time of the decision in 2007. And many people thought that the decision of a court that is known to have political flavor sometimes in its decisions, many people thought that there might have been a political flavor or overtone to this decision. Since then, of course, further evidence has come available. For example, the documents that were blacked out from public view and from the view of the International Court of Justice judges have become available. They might, in themselves, have generated an application for revision of that decision when they became available in the Perisic trial. What was very concerning for those of us who probably count ourselves as friends of Bosnia is that although advised that that was a step that could be taken, nobody showed any interest. Indeed, I'm not sure that anybody in Bosnia, journalist, researcher, whatever, actually analyzed the fully available documents when they became available.
What do you think, why?
I can't answer that question. As you may know, and if not, it's important your viewers should understand, for revision of the Court of Justice, the International Court of Justice judgments, you have to act within 6 months of the new material coming to light. So that the time for acting on those documents is long gone. And I can't remember interviewed by whom I made this point at the time the documents became available. Why hasn't it been done? Because there is insufficient will, I'm afraid, in your country to take these opportunities to use the court system to the extent a court system can be used to correct records that are unsatisfactory.
You were talking about flavor of politics in that judgment of the International Courts of Justice. Should I say, whose flavor, of what country or individual or whatsoever?
Well, I can't be specific, of course.
Why not?
Because I don't know. I'm not one of the judges and I wasn't there. But those of us who operate in this field hold, without being over-conspiratorial about it, that all the international courts are vulnerable to political pressure from time to time in parts of their workings. All the international courts and tribunals have judges who are, of course, elected by some process or another at the UN or by the states' councils for the Permanent International Criminal Court. They're not simply appointed as the most excellent of lawyers to take the jobs that become open for candidates to fill. And also all these courts have been created, as all courts are, but very specifically by politicians for a purpose. And so it would be surprising if from time to time there wasn't the desire by politicians to exert influence on the courts, and it would be surprising if that influence wasn't sometimes successful.
Has there been such a desire at the International Criminal Courts for former Yugoslavia, Tribunal for former Yugoslavia, the ICTY?
Yes, it's been very clear from time to time, and I've dealt with this in earlier interviews and in lectures and writing. There seemed to be, for example, a very, very clear political purpose in the indictment of Ramush Haradinaj of Kosovo, when the prosecutor had been advised by several teams of lawyers that there was insufficient evidence, and indeed he was acquitted not once but twice following a rather extraordinary retrial. I can't say for certain that there was political pressure, and it may have been internal self-pressure. The prosecutor may have wanted simply to be sure that she prosecuted a Kosovar as well as a Serb. I don't know. But that's one example where people start to get worried. Another was in the blacking out of the Supreme Defense Council records that I've just referred to, which served the interests of Serbia, was completely unjustified by the rules of the tribunal, and yet was acceded to, was agreed to by the tribunal, by judge, and that's a complicated history, we don't have time to go into it, but there are judgments of the appeals chamber that are still secret, so I can't even talk to you about them. And there are other ways in which it's possible to be concerned about political influence, and you'll probably remember that Judge Harhoff from Denmark wrote a letter following some rather surprising decisions. They were surprising objectively viewed, saying that he had been put under pressure by the presiding judge. Now, it has to be said straight away, there are some very odd features about Harhoff's complaint, which would make it not immediately something you'd accept as obviously correct, but in combination with the surprise that we were seeing or we were feeling about the decisions, you put them together and you say, well, there's something here to be troubled about.
And you yourself, you used to be a part of the prosecutor's office at the ICTY. Did you face pressures?
Yes, I faced pressure of different kinds on several occasions. And whenever I faced that pressure, I
From
always did.
whom?
It always came from my superior, the prosecutor, yes. And sometimes you just, you have to deal with it and resist it, because to do otherwise would be to act without ethical responsibility. On other occasions, you can follow a decision you are obliged to follow, recognizing that it will have consequences thereafter. Let me give you a very clear example. It is beyond doubt that at the time of Srebrenica and Žepa, Milosevic was in telephone contact with Mladic. We know that because in a stenographically recorded minute of the Supreme Defense Council, now available, he speaks of talking to Mladic and balancing the military as to the political consequences of what was happening. But he doesn't go further than that. We also know that there were telephone intercepts held by one or other international body or country, and we tried to get them. We had a hearing listed before the court, and at that hearing, I would imagine, the intercepts would have been ordered to be produced unless there was a good national security reason on the part of whoever held them that they should not be produced. But before that happened, an instruction was given to the prosecutor, and I am not in a position to tell you by whom, that she should withdraw the application. And so she instructed me to withdraw it, and I did.
Can you describe now the work of
I should
Del
say
Ponte.
incidentally, that although I did as instructed, because I had no choice, this wasn't at this stage an ethical issue where I'd have to say, I'm not going to obey you and I will walk away from the case. I nevertheless realized that the problem wasn't over, because if at any stage Milosevic had raised as part of his defense something to which these phone calls, intercepted phone calls, might have been relevant, then my duty to him, my duty as a lawyer to the defendant, which is a very substantial duty, would have been to have told him, look, we tried to get this material, but we were stopped.
What can we say then about work of Mrs. Del Ponte back then? And I talked to some legal experts who would say many indictments at the ICTY were poorly written.
I, of course, only know the indictments I was concerned with intimately, and all I can do is tell you something about the change of practice and policy. When Louise Arbour was in charge as the prosecutor, and she laid the first indictment against Milosevic, there was a process of peer review within the office, so that a team would prepare an indictment and a very large number of people would then be invited from all different disciplines to take part and to analyze it. That policy lapsed, and from that moment on, indictments were drawn by individual teams, but they weren't subject to a broader peer review. And that, of course, was one of the problems with the Haradinaj indictments, because eventually, when 2 or 3 different teams of lawyers said they would not indict him, other lawyers who never went to court, they may have been lawyers in an administrative way, but they weren't ever going to be the guys standing up in court behind the indictment, were instructed to draft an indictment against Haradinaj, and they did as they were told.
By whom?
Well, they did as they were told by Mrs. Del Ponte.
Do we know who instructed her to act in that accordance?
And I'm not sure whether there are, I just don't know what the state of records is within the ICTY about the decision she made. For all I know, there may be the fullest of archives showing the rationale, the reasoning of all her decisions, but I'm not aware of it.
People here sometimes have feeling that the role of ICTY and all other events, the intention was to portray the war in Bosnia and Herzegovina as a civil war, and only that. What do you think?
There was certainly no pressure on us to portray it in that particular way that I was aware of. All sorts of odd conspiracy theories bubble up and go down, but no. And to be fair to Del Ponte, over the Milosevic case in particular, she was determined, and I think rightly determined, to have him tried as a single individual, looking at his responsibility for 3 conflicts that had to be tried together. You'll remember that the judges at one stage wanted to pick off Kosovo and forget Croatia and Bosnia, and she was determined that that shouldn't happen. I fully supported her in that, and indeed, I think it was wrong to take Kosovo first. I think you should have taken Croatia first, then Bosnia, then Kosovo, dealt with it sequentially, and then Bosnia would have been at the heart of the alleged criminality. And that would have been right for 2 reasons, both because of its gravity. It certainly is Srebrenici, which was the only place where genocide was charged, although genocide might easily have been charged in Kosovo. Let's be clear about that. But also because by looking at things chronologically in this case, you would have seen the development of the mental state of Milosevic that much more easily, because he very clearly turned from a man who was not a criminal. He may have been an apparatchik and a banker and a lawyer and all sorts of other things, but he wasn't a criminal. But he turned to the man who ultimately became a common criminal when he had Ivan Stambolic, his former friend and mentor, murdered in cold blood in order to save his Milosevic's political career.
When we describe the work of the ICTY in such a manner, one has to ask himself, were the expectations too high from the ICTY?
I think, and the conference I've been attending rather confirms me in this view, that people expect too much of these modern international courts. The courts were set up by politicians for a range of reasons, including embarrassment, shame at what they hadn't done. They were set up by appointment of judges through processes of election. They were composed of lawyers who were just ordinary men and women who happened to have a particular skill and do a particular thing. You are not appointing gods to look into a problem that's incapable of resolution. That's the beginning. They were set up using terms like reconciliation, which seemed always very odd to me, because you don't have criminal trials to bring reconciliation. You don't seek to reconcile by a criminal trial the rapist with the victim, the burglar with the householder. So expectations were very high. Over time, I think reality set in and people stopped talking about reconciliation, probably recognizing that you need a justice system behind whatever else happens to bring about reconciliation, but you don't ask the justice system to do it itself. But two things. The trials have been immensely important and successful, not just the Yugoslav trials, but all the trials in two ways. First, the world citizen now expects there to be accountability following a conflict. That was not the case 23 years ago. Before these courts existed, people wouldn't say send him or her to The Hague because there was nowhere to send him. And yet all of us now, when we look around the world, on television and with the limited amount of time that the man or woman who has another job to do can devote to world affairs, he looks at it and says, that guy should be sent off to be tried. That's a huge change. And providing it remains, it's a change that will ultimately turn to good effect. And the second thing, particular to the Yugoslav trials, is that there's an immense amount of material made available in the course of the trials for all of us to look at, today's citizen, tomorrow's historian. And much of it, in the case of the Milosevic trial, but also in the case of Šešelj, questioned by the defendant in person, so that you can see what would have been his defense, even if the trial never reaches a solution. So there we are.
What went wrong about case against Šešelj, about Vojislav Šešelj? And there are complaints that many cases lasted too long.
I'm not particularly knowledgeable about the Šešelj case. To be knowledgeable about that case would be a full-time job. I find it quite extraordinary that the case lasted as long as it did. And I can't help feeling with a high degree of probability that there must have been a way of shortening it, either to say there was no charge that could be proved against him, or to bring the case to an earlier conclusion. Putting that case on one side, as to the length of cases generally, yes, they are long. The Milosevic case wasn't as long as it seems because he was ill so much. It was actually a 2-year case, which for 3 wars may not be, if it had been tried in ordinary court days, one after the other, it would have lasted about 2 years. That's not too bad for 3 wars lasting 10 years. And if you look at Human Rights Watch's analysis of the evidence, they acquit us of being too slow. But the reason these cases take a long time, apart from the fact that there are very substantial issues involved, is in part the adversarial system of trial. There's the English system, the American system, the Australian system that was introduced, which some people think takes longer than the civil system, the inquisitorial system. But since the inquisitorial system's never been tried, we don't yet know. The second thing is that there was quite a conservative approach towards evidence by the judges. Conservative and hard to shift. I managed to shift procedurally our court in a number of ways to speed up the process, to accept more evidence in writing and so on and so forth. But it was very difficult to do. And I'm not really sure the courts looked at the problem sufficiently from the victim's point of view. Because if there's no victim and you want to spend 10 years on a trial, well, does it matter? But there's always a victim. And the victim should be the most important person. And you should, as a court system, as a judge, you should be looking at the victim and saying, that victim, those victims, need resolution. And we have got to divine a process, you can imagine yourself saying, whereby they have a satisfactory result in a reasonable period of time. And if that means adjusting our procedures to make them move more swiftly, if it means us, the judges, working longer hours, if it means paring down the indictment to the core of the indictment, we should do that, because you can't leave victims for 5, 6, 7, 8, 9, 10 years.
Speaking about victims, the release of Vojislav Šešelj, temporary release of Vojislav Šešelj, was painful to many people throughout the former Yugoslavia. And there are some comments throughout the region that his release from ICTY custody was politically motivated. So is it possible at all?
It's possible, and I can't comment further, not because I'm not willing to.
Do you believe in it?
I don't know enough. With propositions like this, if I express any qualified agreement, that's likely to get a headline more than it really merits. I really don't know. It is surprising that he was released in the circumstances that he was.
Again, victims. What can you say to the victims, especially of genocide here in Bosnia and Herzegovina? What can be done to overcome consequences of denial of immense atrocities?
I firmly believe that there is a risk of people in Bosnia expecting too much of outsiders, expecting too much that outsiders will deal with these things for the people of Bosnia. Outsiders are full of well-wishers. I dare say I'm a well-wisher myself, but we don't have that much power, and we don't have that much time, because we have other things to do, and there are other serious conflicts around the world that have to be dealt with. The time has certainly come, and this conference is good in that it shows that this is really recognized. The time has come when the people of Bosnia have got to be determined to set their own record straight, because it's not necessarily being set straight by Serbia, and it's not necessarily being pressed for correction by the international community or even by Europe. There are two things, obviously, that the people can do if they have a will to. One is to take whatever opportunity may come their way and go for revision of the International Court of Justice decision. You may well find that there are even judges in that court who would like to see the matter re-argued, but they can't do it without an initiative, and I'm not saying there are such judges, I'm just saying there might be. And although failure would be disappointing, even setting out the fact that that decision is regarded by the government of Bosnia as wrong will be one step. As it stands at the moment, there's the judgment, Serbia not guilty of genocide, and what has the government done? Nothing. It hasn't even said, we assert in a formal way that that is wrong. As I explained yesterday in the conference, in an opening speech, the one thing you can be sure about in the legal process is this. If you're in a legal process, or maybe, if you don't try, you will fail. If you try and fail, you can sometimes try again, and the process of trying can serve a purpose. The second thing that people can do, if it's not possible to get a formal sort of stamped version by a court, is you can set up your own process of recording history. There are things called informal tribunals, which are increasingly common, possible to do even by a state, low cost, and where you say, well, we're not going to be able to get an answer from an official body, so we will set up a body with all the characteristics of independence that you want, to which evidence can be presented, to which the other side can present its evidence. And that body will make a record of facts. That's something that I've suggested. That's something that hasn't been picked up either.
Do you feel it's going to happen in the near future or any time?
I'm afraid much though I like being in Sarajevo, much though I enjoy the companionship of the people who I know here, I'm not convinced that there's the resolution to get it done.
There is a sense that there is somebody, some outer force or whatever, who is trying to do that, and giving political flavor, as you've described, to international courts and setting politics in that way. So can those international courts be trusted at all?
In answer to your question, do I sense that there may be somebody, I suppose the answer is I sense that there may be something or somebody somewhere. But then, as I said several questions ago, these courts were created by politicians, and politicians aren't that keen to let them go. They're always going to...
But yet you're a part of such a court, and people would say, did he have a chance to say that thing, or willingness to say something while he was the prosecutor?
Well, I've already explained to you, whenever I was presented with improper pressure, I dealt with it, and sometimes in a very brutal way, and no doubt in ways that made me no friend of the United Nations or of the ICTY. On the contrary, I have no doubt, the person they least wanted there sometimes, because I wouldn't let things happen that others wanted to happen.
Sir Geoffrey Nice, thank you very much for this
welcome.
interview. Poštovani gledalci, ova emisija uvijek i na portalu aljazeera.net/Balkans. Hvala vam na pažnji.